Chapter 19 of Criminal Procedure Code 1973. It's trial of warrant cases by magistrate. It has got total 13 sections, section 238 to 250. This chapter is divided into 3 parts. Let's check what they are.
Oh, look at that for a shot. Moved around in the crease and then Virat Kohli just went bang!
Hello. Looks like he checked his shot. Well, once Minoff was up in the circle, he was always going there.
It's low, it's hard, and it's 4. Don't give up India with this man at the crease.
Did I say
83.
too early? Did I?
Well, Virat's out there. Needs to go. He needs to go now, and he needs to go large.
Trial by magistrate starts from section 238. So remember this starting point. Trial of warrant cases by magistrate starts from section 238 and ends with 250. Total 13 sections. Now it's divided into 3 parts. We have already covered the trick. If you need 13 runs in 3 balls, how you gonna do that? 6, 4 and 3. Chapter 19 is divided into 3 parts. A, B, C. How do we initiate a case in a magistrate court? Well, either on a police report or otherwise than a police report. So there are only 2 ways. The third thing is the conclusion of the trial. So do you remember? Cases initiated in a court of magistrate starts from section 238. If you add 6, it becomes 243. The first ball, it was a 6 run, if you remember the starting of the video. Then the second way to initiate a case is otherwise than a police report. So second ball, it was 4. So if you add 4 runs to 243, it becomes 247. And conclusion of the trial, last ball, we took 3 runs. So add 3 to 247, it becomes 248 to 250. Part A, cases instituted on a police report. First section, section 238. It says compliance with section 207. Now let's cover first part A. Cases instituted on a police report. It has got 6 sections. Now I hope you remember, police report is given under section 2R and it is forwarded to magistrate under section 173 subsection 2. So to initiate a case, to start a case in a court of magistrate, what is the first thing to do? Section 238 informs us that we should check the compliance under section 207 is done or not. Now section 207 is, it supplies to the accused of copy of police report and other documents. So now I hope everybody has understood this point, that under section 238 it is informed, it is instructed, it is a mandatory thing that police report and other documents attached with the police report should be given to the accused so that he can defend himself. Without this, a case cannot be initiated. Now let's read the bare act of the language. It says, when in any warrant case instituted on a police report, the accused appears or is brought before a magistrate at the commencement of the trial. So I hope you understand the meaning and the difference between the accused appears means he appears on his own, or is brought before a magistrate, which means he has been arrested, he is being forced to come, he is being forced to attend the magistrate's court. And this is going to happen at the commencement of the trial. Now at this condition, what's going to happen? The magistrate shall satisfy himself that he has compiled with the provision of section 207. So I hope section 238 is very clear now. Section 238 covered. After checking the compliance with section 207, we come to section 239. It says, when accused shall be discharged. Section 239 informs us that upon an application, what the magistrate is going to do. First, he is going to check the police report. Second, he is definitely going to check the documents which are sent under section 173 along with the police report. And after making such an examination, the third thing that comes to the mind is, if any of the accused as the magistrate think necessary, and after giving the prosecution and the accused an opportunity of being heard, which means the third thing what the magistrate is going to do is he is going to give the opportunity to both the parties. So we have done all the 3 things. Now section 239 informs us that the magistrate considers that the charge against the accused to be groundless, means there is no such grounds that he thinks he has committed the crime. then he shall discharge the accused and record his reason for doing so. Let's take up a case. State of UP versus Jitendra Kumar Singh, 1987, Criminal Law Journal, 1768 ALL. There were sufficient documents and evidence indicating that the prima facie charges were made out against the accused. But those documents were neither referred to nor considered, and the magistrate discharged the accused on the grounds that nobody represented the state, nor any advocate appeared, nor any district government council came up. Well, do you think this was justified? No, obviously. It was held that the order of discharge was liable to be set aside. So when a case is instituted on a police report, first thing we check is the compliance under section 207, which is 238. 239 says if there are no grounds to frame charges, accused shall be discharged. But if there are grounds to frame the charges, then section 240 says framing of the charges will be done. It is further divided into two parts, subsection 1 and subsection 2. Let's cover it in detail now. Section 240 is framing of charges. Subsection 1 says, upon consideration, examination and hearing. Now CEH is the code word. Consideration, examination and hearing. After this, the magistrate is of the opinion there is ground for presuming that the accused has committed an offence. Now in section 239, upon consideration and examination and hearing, if any. The same code word, that after this, the magistrate was of the opinion that there was no grounds. So he was discharged. But now subsection 1 of 240 says, upon consideration, examination and hearing, the magistrate forms an opinion that there are grounds for presuming. Now I'm stressing on the word presuming because he's presuming right now that the accused has committed an offense triable under this chapter. So these are all the conditions to be fulfilled before we frame the charges, that it should be triable under this chapter. Which such magistrate is competent to try means he should be competent to try such an offence. In his opinion could be adequately punished by him, he shall frame in writing. So another important thing to note over here is that the framing shall be in writing. Frame in writing a charge against the accused. So what are the important things we covered under subsection 1 of 240? First, we are presuming that the offence has been committed. Second, that the magistrate is competent to try such crime, and that he can be punished by him. And finally, the framing of the charges will be done. And subsection 2 of 240, it says when the framing of charge is done, the charge shall then be read and explained to the accused, and he shall be asked whether he pleads guilty of the offence charged or claims to be tried. So if section 240 is very clear to you, then you must like this video. So how cases instituted on a police report? First we have to check the compliance under section 207. This is what section 238 informs us. And if there is no grounds on the allegations, then the accused shall be discharged. This is what section 239 says. And section 240 says if there are grounds on the allegations, then the framing of the charge will be done. How do we check there are grounds or not? Well, simple. CEH. Checking, examining and hearing both the parties. Now we come to section 241. It says conviction on plea of guilty. Section 241, it's a very small section. It informs that if the accused pleads guilty, so this is the condition. If the accused pleads guilty, only in this condition, the magistrate shall record the plea and may in his discretion. Now in his discretion means the magistrate has the option either to accept or reject it and convict him thereon. Ram Prasad versus State of UP, AIR 1973, Supreme Court 2673. In this case, it was held that the prosecution is bound to produce witnesses who are essential to the unfolding of the narrative on which the prosecution is based. But it cannot be laid down as a general rule that the prosecution is bound to call all eyewitnesses. So if you have some witnesses who proves the case itself, you don't need to ask others to come as well. Have you checked this? TOWCBM, what is this? It's trial of warrant cases by magistrate. What? You already knew it. Okay, let's proceed then. Section 242. The case always begins evidence for prosecution. Section 242 subsection 1. It has got many options. Check it properly. It has got many conditions. If the accused refuses to plead guilty, okay. Second thing, if the accused does not plead guilty, okay, Third option, if the accused claims to be tried. Okay, now, no. If the magistrate does not convict the accused under section 241, section 241 is when the accused said, I am guilty, but the magistrate says, no, I want to check it out. So in such all conditions, the magistrate shall fix a date for examination of witnesses. This means the case is going to be processed. Provided that, now there is a condition to it, the magistrate shall supply in advance to the accused the statement of witnesses recorded during investigation by the police. So now the case is initiated. Subsection 2 of 242 says the magistrate may on the application of the prosecution. So this action is taken on the application of the prosecution. The magistrate will issue a summons to any of its witnesses directing him to attend or to produce any document or thing. And subsection 3 of 242 says, on the date so fixed, the magistrate shall proceed to take all such evidence as may be produced in support of the prosecution. This is how the evidence for prosecution begins. Provided that, now there is a condition to it as well. The magistrate may permit the cross-examination of any witnesses to be deferred until any other witness or witnesses has been examined or recalled any witness for further cross-examination. This is actually done in the interest of justice, not to make a favorable condition for others. Subsection 1 of section 243 informs us the accused shall then be called upon to enter upon his defense and produce his evidence. It further informs us, and if the accused puts in any written statement, the magistrate shall file it with the record. So what do we understand? Number 1, the accused to bring his defense. Second, his evidence. And if the accused bring his written statement, the magistrate will file his written statement. And subsection 2 informs us, if the accused after he has entered upon his defense applies to the magistrate to issue any process for compelling the attendance of any witness for the purpose of examination or cross-examination or the production of any document or thing, the magistrate shall issue such process. So subsection 2 is informing us that the accused can request the magistrate that he needs for his defense and attendance of any person or a thing or a document to be cross-examined or examined, and magistrate will definitely allow it. But the section further informs us, unless he considers that such application should be refused on the ground that it is made for the purpose of vexation or delay or for defeating the ends of justice, and such ground shall be recorded by him in writing. This means that the magistrate is having the option that he can either accept his request or reject the request of the accused person. If he is rejecting the request of the accused person, the magistrate has to mention why he is doing so. Basically, the section is informing us that he will refuse only if the magistrate thinks that it is just to delay and waste the time of the court or is not necessary. So all these reasons shall be recorded by the magistrate. Further, there is a condition to this section. It says, provided that when the accused person has cross-examined or had an opportunity of cross-examining any witness before entering on his defense, the attendance of such witness shall not be compelled under this section unless the magistrate is satisfied that it is necessary for the ends of justice. Now, this is a condition which arises when cross-examining of any person has already been done and the accused wants it to be done again. So the attendance of such witness shall not be compelled, means he will not be forced to come to the court again. It depends only on the magistrate whether he thinks it's necessary for the ends of justice or not. And subsection 3 informs us the magistrate may, before summoning any witness on such an application under subsection 2, which is the request of the accused person. So what the magistrate is going to do? It says, reasonable expenses incurred by the witness in attending for the purpose of the trial be deposited in the court. So it's just helping the witness that we will pay for your travel expenses. At least you don't be burdened with it. So I hope section 243 is very clear now. Venkateshwara Rao versus State, 1973 Criminal Law Journal 255, Andhra Pradesh. The High Court of Andhra Pradesh considered the words may require used in section 243 subsection 3 and held that the requirement of depositing the expenses of witnesses could be insisted upon in cases where the accused has the capacity or means to pay the expenses. So it is an optional thing. If he cannot pay, definitely the magistrate can avoid to put such expenses so that it is not a burden on the accused. So chapter 19 trial of warrant cases by magistrate starts from section 238, ends with 250. Part A we already covered. Now we come to part B. When case is instituted otherwise than on police report. It has got 4 sections, section 244 to section 247. Let's cover it up. Before we cover part B of chapter 19, let's go into flashback first. Chapter 12, section 154, subsection 1. It was informed FIR only in cognizable offences will be registered. But what if the police refuses to register your FIR? Then it was informed in chapter number 15, complaint to magistrate can be made when police refuses to register your FIR. And in section 200, examination of the complaint was done by the magistrate, and section 203 informs that complaint can be dismissed by magistrate, that the complaint is not genuine. But if magistrate accepts the complaint, then chapter number 19 part B comes into force. Cases instituted otherwise than on police report, when magistrate takes up the complaint. And first section is section 244, evidence for prosecution. Let's cover this section in detail now. Subsection 1 of section 244 informs us when in any warrant case which is instituted otherwise than on a police report. Since no complaint FIR was registered by the police, so the case was instituted by making a complaint to the magistrate, but it is instituted in warrant case. These are the two things to be noted. The accused appears or is brought before the magistrate, so the accused is now being questioned. We already know that. And the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. So the prosecution is the complainant who made the complaint to the magistrate. Now he is being listened, his evidence being checked. And subsection 2 informs us the magistrate may, on the application of the prosecution, issue summons to any of its witnesses directing him to attend or to produce any document or other thing. So the prosecution might have requested the magistrate that in support of his complaint, he wants certain persons to attend the court as a witness or persons to bring some document or other thing which will support his complaint. So definitely the magistrate will, if it seems necessary, direct them to attend the court or direct them to bring any document or thing which is under the custody or under the control. After checking the evidence for prosecution under section 244, now we come to section 245, when accused shall be discharged. Let's cover it in detail now. The heading of section 245 itself informs that the accused shall be discharged. How? There are 2 points. Subsection 1, it says if upon taking all the evidence referred to in section 244, the magistrate considers for reasons to be recorded. Now he has to record the reasons that no case against the accused has been made out. If unrebuted would warrant his conviction, the magistrate shall discharge him. If unrebuted would warrant his conviction means even if the case is being processed, the accused will not be convicted. So why not discharge him? And subsection 2 informs us, nothing in this section shall be deemed to prevent a magistrate from discharging the accused at any previous stage of the case, if for reasons to be recorded by such magistrate, he considers the charge to be groundless. So there is no specific timings when the magistrate can discharge the accused. But if the magistrate is discharging the accused, he has to give the reasons, and that is going to be recorded as well. Basically, if the charges are groundless, the accused shall be discharged. Now let's check the difference of discharge given in section 245 under subsection 1 and subsection 2. Discharge under subsection 1 of 245 can be passed when magistrate finds that no case has been made out. And discharge under subsection 2 of 245 can be passed when magistrate considers charge to be groundless. This is where the difference stands when you give judicial examination. So this channel J law classes makes the difference. Section 244 informs that the evidence for prosecution shall be taken, and Section 245 informed when accused shall be discharged if the complaint is groundless, and Section 246 informs us procedure where the accused is not discharged. Section 246 informs regarding procedure when the accused is not discharged. Do remember, there are 6 subsections to Section 246, and subsection 1 informs if when such evidence has been taken or at any previous stage of the case, the magistrate is of opinion that there is ground for presuming that the accused has committed an offence triable under this chapter, which such magistrate is competent to try and which is, in his opinion, could be adequately punished by him. He shall frame in writing a charge against the accused. Okay, there are 5 things that you need to remember from subsection 1 of section 246. 1. The evidence has been taken. 2. There are grounds of presuming that the accused has committed an offence. 3. The offence is triable under this chapter. 4. The magistrate is competent. 5. The magistrate is going to frame the charges in writing. And subsection 2 informs the charge shall then be read and explained to the accused, and he shall be asked whether he pleads guilty or has any defense to make. In subsection 2 of section 246, there are 2 things that we must remember. 1. The charge shall be read and explained to the accused, and 2nd, that he will be asked whether he pleads guilty or he wants to make his defense. And subsection 3 informs if the accused pleads guilty, the magistrate shall record the plea and may in his discretion convict him thereon. So subsection 3 is informing that if the accused accepts his offence, his guilt, the magistrate will record, but in his discretion means the magistrate is having the option whether he wants to convict him or not. Subsection 4 of section 246, it informs if the accused refuses to plead guilty, does not plead, claims to be tried, or if the accused is not convicted under subsection 3 by the magistrate, he shall be required to state at the commencement of the next hearing of the case, means on the next date, or if the magistrate for reasons to be recorded so thinks fit, forthwith, whether he wishes to cross-examine any, and if so, which of the witnesses for the prosecution whose evidence has been taken. So subsection 4 informs us, in such a condition where accused refuses to plead guilty and claims to be tried, or in third option where he pleads guilty but magistrate has not convicted him, then the accused shall be asked on the next hearing that which witness of the prosecution he wants to take up for evidence for a cross-examination and whose evidence he wants to take up. And subsection 5 says, if he says he does so wish, the witnesses named by him shall be recalled, and after cross-examination and re-examination if any, they shall be discharged. So subsection 5 is informing us that the accused can name the witnesses that he wants to either cross-examine or re-examine the witnesses of the prosecution, and after that they will be discharged. And subsection 6 informs us the evidence of any remaining witnesses for the prosecution shall next be taken, and after cross-examination and re-examination if any, they shall also be discharged. So this is regarding the remaining witnesses that the prosecution wants to bring up. He can bring up next, and they can also be called, examined and re-examined. After that they will be discharged. I hope you enjoyed section 246 as well. So after taking the evidence for prosecution under section 244, 245 says the accused can be discharged, and 246 says when the accused is not discharged. And now we come to section 247 where it says evidence for defense. Since the accused has not been discharged, the section says the accused shall then be called upon to enter upon his defense, obviously, and produce his evidence. And the provision of section 243 shall also apply to the case. So what do we understand from section 247? It basically says after the charges is framed, two things gonna happen. One, the accused has to bring his defense evidence, and as given in section 243, the evidence for defense shall be taken up. This is also a way of learning, bringing this back again and again. Trial of warrant case by magistrate starts from section 238. Part 1A, cases instituted on a police report, done. Part B, cases institute otherwise than on a police report, done. Now we come to the conclusion of the trial. It goes 3 sections, section 248 to section 250. Let's cover it up. So in trial of warrant cases by magistrate, section 248 plays an important role. It is of judgment of acquittal or conviction. Subsection 1 of section 248. If in any case under this chapter in which a charge has been framed, the magistrate finds the accused not guilty, he shall record an order of acquittal. So subsection 1 is regarding order of acquittal. But remember, after the charges has been framed, and second thing, the magistrate find the accused not guilty, then order of acquittal will be passed. So remember these two things in subsection 1. And subsection 2 of 248 speaks about where in any case under this chapter the magistrate finds the accused guilty but does not proceed in accordance with the provision of section 325 or section 360, he shall, after hearing the accused on the question of sentence, pass sentence upon him according to law. So most important part of subsection 2 is that sentence is passed, he is convicted, that the magistrate has not taken a decision to proceed under section 325. 325 is when a magistrate considers to transfer the case to senior judge or chief judicial magistrate so that more severe punishment can be done. This means that he was not competent to pass that sentence, so he has to transfer it. In that case, he will not pass the sentence. He will not convict him. And other condition is that in case in section 360, which is regarding orders to release on probation of good conduct or after admonition, if these two things has not been done, then he is going to pass the sentence, means he is going to convict the accused. Now subsection 3 of section 248, it speaks about where in any case under this chapter a previous conviction is charged under the provision of subsection 7 of section 211 and the accused does not admit that he has been previously convicted as alleged in the charge, the magistrate may, after he has convicted the said accused, take evidence in respect of the alleged previous conviction and shall record a finding thereon. See, this section comes into force only if in charge it has been alleged that he has been previously convicted in an offense. Second thing, that such case shall be taken up only if the accused says that no, it is false, I was not convicted in previous conviction in any previous case. So magistrate is going to bring that file of his previous case but only after he has been convicted, which means before the decision the previous case shall not be opened, so that a biased mind is not being prepared that he is a habitual criminal, but only if it is confirmed that he has committed the crime, then to enhance the punishment the previous case shall be opened or checked, provided that. Now this means subject to condition. What are the conditions? No such charge shall be read out by magistrate. Okay. Nor shall the accused be asked to plead guilty. Okay. Nor shall the previous conviction be referred to by the prosecution. Okay. Or in any evidence adduced by it regarding his previous conviction. Okay. We are not going to do all such things. This is not going to be done unless and until the accused has been convicted under subsection 2. Once the accused has been convicted, then the magistrate is going to read the charge, ask him whether he pleads guilty or not, and will check the previous conviction. Got it? Okay. So conclusion of trial section 248 directly informs regarding the judgment of acquittal or conviction. And section 249, it's an interesting thing. What if the complainant is absent? Absence of complainant. Let's check this out. Section 249, absence of complainant. This is an answer to an interesting question. Let's check it out. When the proceedings have been initiated upon the complaint and on any day fixed for the hearing of the complaint is absent. Yes, a person can complain to the magistrate and does not appear in the court. So in such a situation, what's gonna happen? If the offense is lawfully compounded and not a cognizable offense, the magistrate may, in his discretion, means the magistrate has the option either to process without him, or the section says, notwithstanding anything herein before contained, at any time before the charge has been framed, discharge the accused. So the magistrate in his discretion may either frame the charges or discharge the accused. Remember an important condition, that magistrate can do so only if it is a complaint which is not a cognizable offense. This is also trick when we come back to this again and again. Section 248, subsection 1 is acquittal, section 248, subsection 2 is conviction. Acquittal and conviction both in section 248. And section 249, it is about absence of complainant. Now we come to section 250. Compensation for acquisition without a reasonable cause. It has got 8 subsections. It's very easy and we'll cover it very quickly. Section 250, subsection 1. Before I begin, let me inform you, you can also say that this is regarding penalty, fine or punishment for making false complaint or a false case. And this is not limited to complaint to magistrate only, as this chapter says. Let's cover the section. Subsection 1 of section 250 informs that if any case is instituted upon a complaint, upon information given to the police officer, means FIR or the police report, or complaint to a magistrate, in all the cases where there are one or more person, as there may be, no problem. If you have accused many person before a magistrate of any offense triable by the magistrate, okay, the magistrate by whom the case is heard discharges or acquits all or any of the accused. Further it says, and is of the opinion that there was no reasonable ground for making the accusation against them or any of them. Then, in this case, the magistrate may by his order of discharge or acquittal, if the person upon whose complaint or information the accusation was made is present, if he is present obviously, and if he is not present, he'll call them up, to show cause why he should not pay compensation to such accused or each of them or any of such accused, where there are more than one, or if such person is not present, then direct issue of summons to him to appear and show cause as aforesaid. So what is the important thing to remember? 1. The complaint was made in any form, but it is a court of magistrate. 2nd, the magistrate discharge or acquits all of them. 3rd, the magistrate is of the opinion, now this is the important part, that there was no reasonable ground for making accusation. Now this is the part where we come to know, okay, this was a false accusation, a false complaint, a false case. In such condition, the magistrate will ask why we should not impose a penalty or fine on you. Got it? Section 250, subsection 1. This is where the magistrate imposes the fine, and this is where the most of the students commit mistake in judicial examination when a question is asked, under which section magistrate can impose a fine for false accusation. Maximum students says subsection 1 says it, which is wrong. Subsection 1 of 250 is show cause notice of the court that why court should not impose a penalty, fine, punishment for false complaint or a false case. But it is subsection 2 which says the court can impose a fine when it is not satisfied with the reply of the complainant, that why he complained, why he made such allegations. Now let's cover subsection 2. The magistrate shall record and consider any cause which such complaint or informant may show, as if he is satisfied that there was no reasonable ground for making accusation, may, for reasons to be recorded, make an order that compensation to such amount not exceeding the amount of fine he is empowered to impose. Means the fine that magistrate is going to impose should be within his competence. He must be competent to award that punishment or a fine. It further says, as he may determine the amount be paid by such complainant or informant to the accused or to each or any of them. I'm using this method so that you can remember rest of the subsections. We have to differentiate things because subsection 2 of 250 we understand the court to impose fine for false complaint or the false case. Rest of the subsections are connected to subsection 2. How? Let's do it. Subsection 3 of 250 informs the fine that was imposed in subsection 2. Remember this? Okay. If that complainant does not pay the fine, he has to go simple imprisonment, but that should not be exceed more than 30 days. And subsection 4 says, if the person refuses to pay the fine or does not pay the fine and punishment of imprisonment is imposed, then section 68 and 69 of IPC will also apply. 68 of IPC says imprisonment will be cancelled if he pays the fine. See, magistrate imposed imprisonment for not depositing the fine if the person deposits the fine later on. So section 68 of IPC says to cancel the imprisonment if the fine is paid. And section 69 of IPC says if part fine is paid, then proportionate imprisonment shall be removed. Subsection 5 of section 250. This is just like an instruction that res judicata is not applicable if the person has been asked to pay compensation under subsection 2 we already covered. That does not mean that he will be exempted from any other civil or criminal liability. So another case on the same subject matter can be initiated against him, provided that now the condition is the amount that is paid as a compensation, the amount shall be considered. Subsection 6 of 250 informs that any compensation which was asked in subsection 2, yes, over here the compensation was imposed, such orders which is more than 100 rupees can be appealed, means they are appealable orders. And subsection 7 of section 250 informs if the appeal has been made under subsection 6 we just covered, then the accused or the informant does not need to pay the fine until and unless the decision on his appeal is taken. And the last one, subsection 8 of section 250. The provision of this section apply to both summon cases as well as warrant cases. With this we come to end of this lecture. Please do respect your elders and love kids, otherwise your education is wasted.